Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the high speed passage. After completion of the investigation, charge sheet under section 302 IPC was filed against the appellant Stop in order to prove its accusations against the appellant. The prosecution examined in all seven witnesses, out of whom PW1 and PW2 were the eyewitnesses. Stop. The documents prepared during the investigation were also filed in support of the case. Stop. The appellant, in his statement recorded under Section 313 of the Code of Criminal Procedure, denied his involvement in the crime. Stop. His plea was that a false case has been registered against him. Stop. However, he led no defense evidence. Stop. Placing reliance on the evidence of the eyewitnesses and other evidence adduced on record, the appellant, as noted above, was found guilty. Stop. The appeal of the appellant against his conviction came to be dismissed by the High Court. Stop. Stanza. Mr. Arvind Kumar, learned counsel appearing on behalf of the appellant, submitted that the High Court committed a serious error in appreciating the evidence of the alleged eyewitnesses and undue importance to the recovery of the weapon of offense has been given. Stop. It was urged that the High Court has failed to take cognizance of the fact that no motive has been attributed to the appellant for commission of the offence. Therefore, the appellant could not have been found guilty of the charge levelled against him. Stop. Learned counsel next submitted that non-examination of Sumit Singh, who allegedly lodged the first information report of the crime in the police station and owner of Sandeep Pan shop, is fatal to the prosecution case, and both these witnesses were intentionally withheld by the prosecution with a view to conceal the true facts of the case. Stop. Thus, according to the learned counsel, the prosecution has failed to establish the charge of murder against the appellant beyond reasonable doubt. Stop. Stanza. Per contra, Mr. Sushil Singh, learned counsel appearing on behalf of the state, supported the judgments of the courts below. Stop. Mr. Singh submitted that the evidence of the eyewitnesses, supported by other ocular and documentary evidence, has been rightly examined and appreciated by the trial court as well as by the High Court. Stop. He submitted that no adverse inference can be drawn against the prosecution for non-examination of the informant and other witness, because the prosecution has fully established the charge against the appellant beyond reasonable doubt by leading reliable and convicting convincing evidence. Stop. Learned counsel further submitted that in the presence of direct evidence, motive recedes to the background, and therefore it is not necessary for the prosecution to prove the motive of the appellant to commit the murder of the deceased. Stop. We are unable to accept the contention of the learned counsel for the appellant that the conduct of the eyewitnesses is unnatural, as they had not disclosed the genesis of the incident to the members of the family of the deceased on the same day, or they had not immediately reported the matter to the police. Stop. Stanza. On scrutiny of the evidence of the eyewitnesses, we have no hesitation to hold that PWs 1 and 2 are natural and truthful witnesses. Stop. Their evidence is cogent, reliable, and convincing, and there is no good reason to disbelieve and discard their consistent and truthful version. Stop. It is well settled that every person who witnesses a murder reacts in his own way. Stop. There is no set rule of natural reaction. Stop. To discard the evidence of a witness on the ground that he did not react in any particular manner is to appreciate the evidence in a wholly unrealistic and unimaginative way. Stop. Therefore, the High Court has rightly appreciated the evidence of the eyewitnesses, and we find no fault in the reasoning recorded by it. Stop. The evidence of the eyewitnesses finds corroboration from the medical evidence. Stop. We do not find any substance in the submission of the learned counsel for the appellant that the evidence of the eyewitnesses needs to be discarded on the simple ground that they are interested witnesses. Stop stanza. A fair and reasonable reading of the judgment delivered by this court on August 24, 2006 in special leave petition number 4957 of 2006 makes it evident that in facts this court did not record any finding that a concluded contract had come into existence between the present appellant and the respondent number 1 herein. Stop. This court noticed that on December 12, 2005, the offer made by the appellant was accepted by the respondent number 1 herein, and the same was communicated to the appellant incorporating the relevant conditions for the sale. Stop. It is nobody's case that those conditions which were stipulated were complied with by the appellant, nor any such finding was recorded by this court. Stop. What is relevant to notice is that in the operative part of the judgment, this court observed that if the respondent number 3 herein makes the payment as promised within such time as might be granted by respondent number 3 and fulfills the conditions of sale, that might be the end of the matter, which means that at the time when the judgment was delivered, this court proceeded on the footing that there was no concluded contract between the appellant and the respondent number 1. Stop. Further, what is relevant to notice is that it is stipulated by this court that if the appellant failed to do so, it was always open to the respondent number 1 to take necessary steps to safeguard the interests, which included inter alia the consideration of other offers made by the other parties. Stop. Such weighty observations would not have been made by this court if this court in the said matter had come to the conclusion that there was a concluded contract of sale between the appellant and the respondent number 1. Stop stanza. As this court has come to the conclusion that there was no concluded contract of sale of the mortgaged property in favor the appellant of by the respondent number 1, the question arises as to whether the right to redeem the mortgaged property conferred by section 60 of the Transfer of Property Act upon the mortgager, that is respondent number 3, can be exercised or not. Stop. It is argued on behalf of the appellant that both the High Court of Bombay as well as this court in the previous round of litigation had found that upon continued default on the part of the respondent number 3 in making payment of amount of loan, its properties mortgaged with respondent number 1 were attached and possession thereof was taken over legally in an action under section 29 of the State Financial Corporation Act 1951. Stop. The learned counsel for the appellant contended that the respondent number 3 had never sought to exercise its right to redeem the mortgaged property before action under section 29 of the State Financial Corporation Act 1951 was taken, or even thereafter till it lost up to this court on August 24, 2006, when special leave petition number 4957 of 2006 was dismissed, and therefore the exercise of right to redeem was not only mollified but also to defeat the judgment of this court. Stop stanza. According to the learned counsel for the appellant, the first proviso to section 60 of the Transfer of Property Act 1882 applies with great vigor to the facts of the case, clearly disentitling the respondent number 1 to apply for redemption of mortgaged properties on August 25, 2006 or thereafter, and said right of redemption stood foreclosed both by the acts of the parties and by a decree of the court. Stop.